to acknowledge the importance of this legislation and strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I will associate myself with the statement of the chairman, the statement of my colleague, Mr. Cicilline. Thank Congressman Maloney, and as well associate myself with the words of Congressman Cohen. I just want to take a moment to focus on a specific part of the Non-Debtor Release Prohibition Act of 2021, which is the part that prohibits the use of non-central non-debtor releases in a bankruptcy case. And as it is defined, to get a release called a third-party release, it is a provision in the plan of reorganization releasing claims by a party in bankruptcy against an entity that is not filed for bankruptcy protection. And as well, we know that there are two forms, consensual releases and non-consensual releases, which means it is against the interests of the creditors. And frankly, I don't believe there is a convincible argument that would suggest that you could, in actuality, offend a creditor that come in all shapes and sizes. They are small businesses, they're medium-sized businesses, they're individuals. And those of us who practice law, who've been in the bankruptcy court, which I have for a long period of time, realize the massiveness of bankruptcy. In my own community, there was an explosion in a neighborhood by a business. It was a medium-sized business, but it had been there for 40 or 50 years, but it had not been there as long as it would be necessary to eliminate the rights of homeowners who were shocked in their beds at this explosion. Well, there was an immediacy of bankruptcy, and the numbers of persons in the bankruptcy court were enormous, but they were small mom and pop. They were households. They were single parents living as head of household, and they had to go up against a more sizable corporate interest. I believe this legislation errs and falls, if there is an error, on the right side of justice. How do you take my rights of having the privileges of a court action or being heard in court without my consent? Meaning, how do you eliminate someone who is a culprit in an injustice, like the Sackler family, among many, and I have nothing to say? It may be that I am not in the bankruptcy court because I do not have the ability to have counsel, but for whatever judgment comes that I may be included as a class, I am eliminated from that because the direct culprit or a collaborating culprit who benefited in the opioid tragedy has now been removed and is intact and has their resources. And so I understand my friends on the other side of the aisle in inquiring of judges and having a long-winded process, but judges follow the law. And if Congress dictates this law, and it ultimately is signed by the President of the United States, bankruptcy courts follow the law. And they also can, in certain instances, interpret the law as it proceeds in their court. But I don't believe that they have any sufficient argument to eliminate the rights of a creditor who falls far short in its power, her power, his power, its power, small business, neighborhood association, homeowners, that warrants not providing this legislation to eliminate the use of a non-consensual, non-debtor release that, by its very nature, Mr. Chairman, negates, undermines, hinders, and harms small creditors across the nation. So I ask my colleagues to support H.R. 4777 because I think it falls on the right side of the interpretation of the protection of those who cannot protect themselves and who seek justice in our courts here in America. With that, I yield back.